to include $10 million to implement the first 3 counties starting in March of 2018, almost halfway through the biennium. If those counties are 25% of the cases and the $10 million in funding is only for half the biennium, does that mean the roll-up cost could be as much as $80 million?
Thank you, Mr. President. And to the questioner on the, that is not my understanding. My understanding that the money that has been allocated does in fact take in for the purchase of all of the equipment that's necessary that will be provided to the district attorneys for their use. It should be noted that the state of Oregon, through the Judicial Department, will have the obligation of determining what the recording equipment will be and actually then issuing it to each of the grand jury rooms for each of the counties and maintaining its maintenance as well as backup units. This is very similar, Mr. President, to what we see already in our area of driving under the influence of intoxicants, where we, the state, are on the hook, as they would say, for maintaining the equipment that is used for testing individuals statewide for intoxication and ensuring that the equipment is in fact working. Regarding the other fiscal or financial contributions and obligations of the state, it does in fact require for the money to be put forward for the purchase of the equipment as well as the maintenance of the equipment, and that my understanding is that this allotment that is coming out will in fact purchase all of the equipment that's necessary, and that the other will be used as a draw on the issues that could in fact be raised through the rollout process. It should be noted that what we're going to be doing is having 3 counties that will be going forward under this proposal through a phase-in. They will be reporting out as to recording starting on March 1 of next year, with the other 33 counties coming online in July of 2019.
Will the carrier yield to another question?
He will.
So then, how do you anticipate what the full cost of implementation is for all 36 counties?
The way the Ways and Means has set this up and established this is that one is uncertain as to exactly what the cost is going to be. That is why we're going through the phase-in to ensure that we actually understand what the cost could be in the future that's not anticipated at this time. The money is phased in and also has the money for the rollout of the other 33 counties through the next portion of the biennium. The money is, in fact, going into an allocated, dedicated account for specific purposes.
Will the carrier yield to another question?
Yes.
He will.
How will some counties be expected to absorb the costs of modifying old courthouses to accommodate recordation? And if they cannot afford it, is there a vehicle to opt out?
There's no means to opt out, and there's absolutely no reason to opt out. The bottom line is we're talking about a tape recorder. A tape recorder can sit on top of a table. I'm not sure what type of modifications that any county would actually try to bring forward that would not be able to have one. Electricity already provided there. I think all 36 counties have electricity, and I think having a space on a table to put a recorder was not going to be undue burdensome.
Will the carrier yield to another question?
Yes, he will.
He will.
505 takes the unusual step of having the district attorneys train grand jurors to operate the recording systems. Are you aware of any other states that put grand jurors in this position?
Mr. President, this bill does not call for any training. Absolutely not. I'm not sure if the asker of the question wants to point out where the word training is. What it says there is instruction. Very simple. Here's the on button for recording. Turn it on when the person comes into the room for their testimony. Once they complete their testimony, hit the off button. That is what their training, quote unquote, will be.
Will the carrier yield to another question?
With the carrier yield.
Yes, he will.
What happens if the grand juror, maybe is a senior, not experienced in IT at all, doesn't own a computer? What kind of training will they receive?
Mr. President, the way this works is there are 7 individuals that make up the grand jury. Between the 7, one of them will be designated to be the individual to actually push the buttons to turn it on, push the buttons to turn it off. If an individual doesn't feel that they're quote-unquote qualified to actually turn a machine on and off, I would assume that they would bring that to the attention of the district attorney, who would then appoint someone else to do that work. Clearly, this is not rocket science of turning on and turning off a machine. There's no, at this perspective, at this point, any computers to be used.
Will the carrier yield to a final question?
Lana Sanderson yielded her time. Excuse me.
Will the carrier yield to a final question?
He will.
What happens to court costs if more DAs move to preliminary hearings versus grand jury?
The reality is I will predict that you will not see individuals flocking to the preliminary hearings approach. The reason for that, vast majority of district attorneys and assistant district attorneys in the state want to ensure that they protect the witnesses that are going before either the grand jury or in preliminary hearing. As I stated in my opening, if they go to a preliminary hearing, this is a mini trial. This is an opportunity that the defense actually can cross-examine each and every witness that comes before there. If a county chooses to go to a preliminary hearing, we do in fact have an allocations already set out for the individual district attorney's offices as well as the courts to actually come in front of the E-Board for allocations of unattended expenses based on someone shifting to the preliminary hearing process. But again, Mr. President, I think it's very important to ensure everyone in this body that knowing how well that the district attorneys and their assistants want to ensure that an individual witness is not going to be badgered or somehow intimidated, that they will not be using a preliminary hearing, because that is where the district attorney is going to be exposing the witnesses to cross-examination, where in a grand jury proceeding they do not.
To the bill.
To the bill, please.
Colleagues, Senate Bill 505B is a bad idea, poorly executed. Please note the floor letter from the Coalition of Police and Sheriff in opposition. It sets up a system that I believe is designed to fail. Here at the legislature, we expect our hearings to be professionally recorded and retained. This may be, for some jurors, a complicated issue to discharge under the construct of this bill. Why should we not have the same expectation of the level of recording in this building for grand jury proceedings, which create a situation where it's possible to take someone's liberty? Requiring grand jurors to record grand jury is a transparent attempt to save money, which is more likely to undermine our public system than to improve it. This is a transparent effort to pander to defense attorneys who want any opportunity to intimidate and interrogate innocent victims. Finally, Senate Bill 505B, I believe, will cost tens of millions of dollars to fully implement. While we may throw a few dollars at it now and again, let's be honest, in 4 or 5 years, maybe as soon as 2 years, the state will halt the funding and leave the counties holding the bag. An unfunded mandate by any other name is still the same. This bill doesn't even go into effect until after the 2018 session. There is plenty of time to go back to the drawing board and do it right. Protections for all victims, adequately funded recording by the courts, and fair treatment of police officers. Senate Bill 505 is not that bill, and it is not good for Oregon.
Senator Cruz.